All right, welcome all. This may be a little funky of a video. What I'm doing is because we're going through this transition from half the class being synchronous to everyone being asynchronous, I'm taking the previous synchronous lecture and I'm just smushing it with the asynchronous. So if you see sort of a rough transition between this and the second half of the lecture, which is really going to be focused on, the right to protest. I apologize for that rough transition. So, the beginning of today's Module 3 lecture is on the International Covenant on Civil and Political Rights. In Module 1, we really introduced human rights and social work, and in Module 2, we looked over the human rights system. So, what we're doing today is looking at one of those legal treaties, which is the International Covenant on Civil and Political Rights. So, before we get into the covenant itself, I do just want to, here's our agenda for today. I want to do like an overview or a review, I'm sorry, of modules 1 and 2. We'll go over the International Covenant on Civil Political Rights. That's the ICCPR. You'll notice that a lot of these covenants end up going by their acronyms, and also these optional protocols that you can align or sign on to. And then we'll go into what your a short video on what your discussion post will be about, the recorded lecture discussion post that you get participation credit for. And that's on the death penalty, which is what one of these optional protocols is about. Okay, so I do just want to give, it's a little, funky with asynchronous, but an opportunity for you to review or have a discussion on anything we learned in modules 1 or 2. So as a reminder, in module 1, we talked about what are human rights. We went over Androff's human rights principles and talked about how those are incorporated into the practice of social work. And in module 2, we opened up talking about what is really rights-based social work practice, and then went over the human rights system, which included the Universal Declaration of Human Rights, those treaties or covenants, which we'll look at one example for today, and then their committees, which also in the second half of this lecture, I'm sort of going to mirror that behavior when we talk about the right to protest, where I go through the UDHR, then the ICCPR, and then the committee, which looks at or oversees the ICCPR, the Human Rights Committee, to find the general comment to give more detail about this. So if you have any questions or want to comment on the review, I'm going to open up, oops, sorry, that's my to-do list. I'm going to open up a discussion board. So these are the pinned discussions, so you just can find them more quickly. But if you scroll down to the very bottom, and some of these you won't be able to see yet. There will be a module 1 and 2 review in the basic discussions. I haven't published this yet, but I will publish it once I post this video. Module 1 and 2 review, so that if you have any questions, if you have any comments that you want to make on modules 1 and 2 as a review, if you want any clarification, please feel free to post it there. I always say if you have a question on anything, it's likely that one of your classmates may also have a question. So I encourage you, anything lingering, no question is a stupid question, happy to answer it. Also, if you want to remain anonymous, you can email me and I can post your question with the answer there as well. So, just want to make sure I'm answering your questions in this asynchronous format. All right. So for today, we're going to talk about the International Covenant on Civil and Political Rights. And I'm going to open up the OHCHR website so we can go through the covenant in its totality. But I do just want to break it out so you can see how the covenant is really structured. So Articles 1 through 5 are going to be its overarching provisions. Because this is a legal document, it really needs to spell out and say exactly what is going on. So you'll read, as we read parts 1 and 2, which are Articles 1 through 5, it has the overarching provisions of the legal treaty. Part 3, which is Articles 6 through 27, is going to be the substantive content. So, what are our civil and political rights are going to be outlined in Part 3, Articles 6 through 27. And then Parts 4 through 6, which is Articles 28 to 53, is going to outline the oversight and monitoring mechanisms. So, how do we oversee our civil and political rights, and who monitors them? That is that Human Rights Committee. So, let's open up the OHCHR website and take a peek at this covenant itself. Again, you can view ratification status by country by clicking on that and selecting the ICCPR to see who exactly has signed and ratified these treaties, but we'll get back to that at a later time. It starts with a preamble. If you want to know what parts, you can, in articles, you can see this on the side. But we start with our preamble, which really talks about the inherent dignity, the inalienable rights of all members of the human family, really those central tenets of human rights. And then you see the overarching provisions around self-determination, respect, non-discrimination. These sound very much like our human rights principles, right? Equal rights. Article 4, interestingly, especially in a post-COVID time, talks about in times of public emergency, how our civil or political rights may be threatened, but let me say this, not threatened. In times of public emergency, which threatens the life of the nation, the state parties may take measures derogating from their obligations under the covenant, provided such measures are not inconsistent with other obligations and are not discriminatory. So thinking about how in times of emergency, some of our civil or political rights may be compromised due to protecting the needs of the greater nation state. And this is read very conservatively, just to make sure that our human rights are protected and that nation states can't really abuse that. So part 3, as we said, Articles 6 through 23. And let me just make sure I'm getting that right. Yeah, part 3, Articles 6 through 27, excuse me, is really going to go through the substantive content. So that is, what are our civil and political rights? That means everyone has an inherent right to life. In no countries which have not abolished the death penalty, death shall be imposed. Talking about genocide. Let's see. Torture, cruel, inhuman, or degrading punishment. No one shall be held in slavery. Everyone has the right to liberty and security of a person. It talks about a time of arrest, reason for arrest. All persons deprived of their liberty shall be treated with humanity and respect for the inherent dignity of the human person. No one shall be imprisoned on the ground of inability to fulfill a contractual obligation. So these are our civil and our political rights as outlined by the ICCPR. Everyone has a right to trial. And as you can see, these treaties are providing much more substantive detail than the Universal Declaration of Human Rights, and also keeping in mind that these are legal documents. These are legal instruments that parties sign on to. Everyone shall have the right to recognition everywhere as a person. Freedom of thought. Freedom of religion. Holding opinions without interference, And I also want to challenge you that, we're in the United States of America, where having things like freedom of thought, freedom of person, freedom of opinions without interference doesn't sound very surprising, but there are parts of this world where that is like a very liberal idea. Propaganda for war shall be prohibited by law. And the right to peaceful assembly shall be recognized. The second half of class is really going to be focusing on that. The right to the family is a fundamental group of and shall be protected by state. So really thinking about your right to family. Children shall have the right to measures of protection. This lack of discrimination is really highlighted here. And then this in states with ethnic, religious, or linguistic minorities, people shall not be denied the right to enjoy their own culture. So that's really the substantive part of the ICCPR, the International Covenant on Civil and Political Rights. And then, as indicated, parts 4, 5, and 6 talk about the overarching bodies and the implementation and the oversight of this covenant, excuse me. So you see that it's established, there is an established human rights committee, the number of members that it consists of, how they are elected, the like provisions and process around this, their term limits. So this is really within the covenant, it has the specific rules around the Human Rights Committee and how they run. The committee elections and all of that sort of thing. The reports that they are required to take on and submit is outlined here. And so on and so forth. So I do encourage you to like read through the ICCPR in its entirety, because it's interesting and it's, if you think about it, like this is a legal document. So you need all of these aspects to really enforce, for example, the different aspects of the covenant, how it's subject to ratification within itself. Just the very like specifics of it. That is that sort of like legal specification. But that is what makes it a legal document. You know what I mean? So that is the ICCPR and in all its glory. And so there are also two optional protocols that we have here. So the first optional protocol is offers a system for the Human Rights Committee to receive complaints when there's an alleged violation to the ICCPR. And then there's a second optional protocol which aims at the abolition of the death penalty. So the first one, it's not as, like glamorous, I guess you could say. But it really just talks through this sort of complaint process that's there for complainants to come through and identify when there's been a violation to civil or political rights and how that would go through. So you can read through those 14 articles. And again, this is an optional protocol, so you can go and view that ratification status on the optional protocol. It's this one. You can see even the United States has not taken any action on this first optional protocol, which as we talk and get to our section on American exceptionalism, will be interesting to think about how we signed on to ratify the ICCPR, but maybe not the optional protocol to be held responsible if anyone has any complaint on it. You can see a fair amount of folks have not across the Middle East and into Asia as well, although South America is fully signed on. It's interesting to just think about those like international dynamics. And then there is a second optional protocol as well. And this is really aimed at the abolition of the death penalty. So, again, encouraging you to read through, just talking about how states should take necessary measures to abolish the death penalty within its jurisdiction. Again, if you go to ratification status by country, you may or may not be surprised to see that the United States has also not taken any action on this. I mean, I would reckon to say you're probably not surprised if you're familiar with the death penalty status in the United States. I bring up the death penalty because for me personally, it was really my introduction into human rights. When I think about the term or concept human rights, it first came to me probably like in elementary or middle school talking about the death penalty as someone just like, asking me what side I was on the death penalty, what I thought about it. And that was the first time I ever had to do sort of like that critical thinking or thought project on, well, what do I think about the death penalty? How do I feel? And, growing up in a culture of Law and Order, and Law and Order SVU being, a guilty binge of mine, despite being this, like social justice warrior or whatever. You have that sort of emotive response when you see someone doing something terribly egregious and you think like crime and punishment. Like that is the culture that America stands on. So death penalty from a very emotional place feels justified. But when you come from a human rights lens and you think about like the very right to life, which is written into the International Covenant on Civil and Political Rights, you're really challenged when you think critically and you start engaging in that thought project around the death penalty. So I wanted to share this short video called "The Death Penalty Has Never Been About Justice" by it's this series called Now This. So we'll just watch this and then this will be the prompt. I want you can like take notes thinking about this, and this will be the prompt for your reflection. You're going to use this in conjunction with this the 10 things, what's it called? 10 Reasons to Fight Hate PDF. So after viewing this, you're going to reflect on the death penalty video and use the 10 Reasons to Fight Hate PDF that you read in preparation for this class module and consider how you might engage in advocacy regarding the death penalty in the United States. And listen, if after watching this video and reading, that you are a firm believer in the death penalty, you are welcome to reflect on that in your recorded lecture discussion post. So I don't want to make you feel like you have to take on, a particular opinion about the death penalty. But this is part of that, like just your critical thinking thought project regarding the death penalty and human rights. Thinking about the human rights lens, those human rights principles, that sort of thing. So without further ado, I will play this video for you. These slides will also be posted, so if you want to watch this video on your own and not like a video through a video, you're welcome to do that as well.
Since the death penalty was reinstated in 1976, more than 500 people.
Let me unembed this so we can make sure that that sound is playing as well.
Hi, Mark Barton at Sandy Hook Promise here.
Like my sound never works when
Way into Sandy Hook Elementary School.
500 people.
Okay, sorry, my sound was off on my computer. So we'll get this started again.
Have been executed by the United States government.
Start again.
Since the death penalty was reinstated in 1976, more than 1,500 people have been executed by the United States government. In that time, 190 people who were sentenced to death have been exonerated. And right now, more than 2,400 people are sitting on death row in prisons throughout the US.
In a lot of ways, the death penalty functions as like a 15th century or a medieval solution to a very complicated set of 21st century problems. And the death penalty remains as inhumane as it ever has been.
So, how do we get here? The use of the death penalty in the US can be traced back 400 years to the colonial period, brought to the colonies by European settlers. Laws on capital punishment varied from colony to colony, a foreshadowing of the state-by-state variation that exists today. By the mid-19th century, some states were beginning to question state executions. Still, capital punishment remained largely intact, but to some, the process wasn't efficient enough in exacting cruelty.
Lynch mobs often criticize the state-sanctioned execution processes as being slow and ineffective and costly, and therefore decided that they wanted to take a mechanism into their own hands and issue racial terror themselves.
This is Robert Ponce, an attorney and legal fellow with the ACLU Capital Punishment Project and the ACLU of Southern California.
The state saw the lynch mob as being a direct threat against their authority to issue physical domination and social control over its everyday citizens. And so the state's law enforcement and criminal punishment systems made it a mission to prove to the lynch mob and to society that they could exact retribution to wrongdoers accused of committing criminal offenses.
As lynchings declined in the early 1900s, state-sanctioned executions rose dramatically until the 1930s. Around that time, approximately 160 people were being put to death by the government each year. But these executions didn't have broad support. By the 1960s, public opinion in favor of the death penalty had dropped significantly. Gallup polls found that the amount of Americans in support of capital punishment declined from 62% in 1936 to 42% in 1966. In 1972, the Supreme Court issued a landmark decision that reflected public opinion. The court ruled in Furman versus Georgia that the death penalty was cruel and unusual punishment, which violated the Constitution. This ruling effectively suspended the death penalty nationwide.
In the Supreme Court's decision in Furman v. Georgia in 1972, the Supreme Court compared being issued a death sentence to being struck by lightning.
A justice on the majority of Furman wrote that it was unconstitutional for the death penalty to continue with a system that allows for executions to be so wantonly and so freakishly imposed. In other words, the Supreme Court saw the death penalty as arbitrary. After states imposed additional rules to supposedly eliminate its arbitrary use, capital punishment was reinstated in 1976, just 4 years later.
We hold that the statutory system under which Gregg was sentenced to death does not violate the Constitution.
Since then, more than 1,500 people have been executed across the country. Yet the death penalty continues to be arbitrarily applied. Whether or not someone lives or dies depends less on what they do and more on unrelated circumstances. Firstly, it varies depending on location. 26 states have abolished or placed a moratorium on the death penalty, but 24 states still enact capital punishment, and the decision to seek execution is up to local prosecutors. So whether or not you're sentenced to death could depend not only on what state you're in, but what side of the county line you're on.
5 counties in Texas and in Oklahoma are responsible for most of the executions that have taken place within the last several years.
It's not a coincidence that those states are in the South, where the Civil War-era lynch mobs that paved the way for capital punishment were most prevalent.
100 years ago, Black people accused of committing crimes against white people were among the primary targets of the lynch mob. Today, the death penalty system in the United States continues that trend.
In some states, those convicted of crimes against white people are significantly more likely to face the death penalty than those involved in cases with Black victims. Black defendants are 4 times more likely than white defendants to be sentenced to death. Black people also currently make up 41% of those on death row, despite representing only 13% of the general population. Additionally, Black people are 7.5 times more likely than white people to be wrongfully convicted of murder, yet they're more likely to face a longer imprisonment prior to being exonerated. Beyond the fact that the death penalty is sought and applied in a random, unjust manner, it's also really expensive.
When the Trump administration resumed federal executions after a 17-year hiatus, it cost $4.7 million to conduct the executions of the first 5 people executed during the summer of 2020.
There are several reasons why executions are so costly. On top of funding the prosecution and the judge, taxpayers often also cover the cost of the defense attorneys because many people facing death sentences can't afford their own legal representation. Additionally, capital trials are a lengthy process. They can be 4 times as long as a regular trial. And while those on death row are in prison, many are in solitary confinement, which is more expensive for departments of corrections than Gen Pop. What's more, everyone on death row is entitled to multiple appeals, which are complicated processes that can take decades.
One major thing about the immense financial costs of the death penalty is that so many people are wrongfully convicted and later have their sentences overturned on appeal.
So given everything we know about the arbitrary and discriminatory nature of the death penalty, who is it really serving?
Many victims' families don't want to have anything to do with an execution, much less to have the memories of their lost loved ones be continuously litigated in a court in a very public setting.
But there are still plenty of people who are in favor of capital punishment. As of 2022, 55% of Americans surveyed in a Gallup poll supported the death penalty.
There are many people within society who continue to advocate that the death penalty is necessary to exact retribution or justice, but the death penalty has never been about justice. It is about retribution, it's about vengeance, and some of our ugliest societal impulses and urges. But the death penalty's history tells no lies. It is a history of racial animus. It is a history of arbitrary application. It is a history of executing the most vulnerable people within society. And the death penalty remains as inhumane as it ever has been.
The US is one of the few democratic nations that still uses capital punishment. In fact, more than 70% of the world's nations have gotten rid of the death penalty. It's time Americans ask themselves, do we want to be a country that allows the government to arbitrarily decide who gets to live and who gets to die?
Okay. So reflect on that video and report out in your week 3 recorded lecture discussion post. You may want to pause this video here because what I'm going to do is I'm going to take there's going to be a second half of this video which really focuses specifically on Article 21 of the ICCPR, which is focusing on the right to peaceful protest. Sorry for the scroll. The right to peaceful assembly. We're going to dive into this. We're going to follow Module 2's framework, going from the UDHR to the ICCPR, and then we're going to jump into the Human Rights Committee treaty body website, find a general comment, define it, use a case example, and that's going to be the focus. It's going to be related to our asynchronous learning activity and our week 3 discussion post. So you may want to pause this video here and complete that recorded lecture discussion post before moving on. All weeks won't be like this. This is just sort of our transition period. So I do want to thank you for your patience as we sort of navigate these unexpectedly bumpy waters. But I am grateful for you all being here and look forward to the rest of the semester. So stay tuned and enjoy the rest of the lecture. Hey everyone, welcome to the synchronous portion of Module 3. I figured what we do today is build on what we've previously learned in E-Modules 1 and 2. I'm thinking about a human rights-based practice for social work and really utilizing the sort of overview of the human rights system and applying it specifically to the International Covenant on Civil and Political Rights. So as you may surmise, the asynchronous portion is really focusing on a right to protest and peaceful assembly. So you should have read this ACLU article. It's just a brief article about this Supreme Court case Doe versus McKesson, which really affirmed a First Amendment right protection to protest. Basically, what happened is John Doe was a police officer, and they brought a court case against DeRay McKesson, who is a civil rights leader, came out of the Ferguson protests in 2014, and the Supreme Court declined to hear the cops' case against DeRay. This lasted almost a decade, as you can see. The Ferguson protests were again in 2014, and they just finally decided to not hear this in April of 2024. So to start out, I just wanted to give you like a little bit of context, and you can certainly read more about this yourself if you're interested. If this is something that interests you, if Black Lives Matter is a passion project of yours, I encourage you to read more about this because it's a little complicated, so to speak. But basically, what happened is there was a protest in Louisiana in the aftermath of Ferguson. Things started to build up. People became more aware of police brutality. And this particular protest occurred in Louisiana after the police murdered Alton Sterling. And so DeRay McKesson is a protest leader. He's a Black Lives Matter activist, and he organized this protest in Baton Rouge. And throughout the protest, tensions got high between the police and the protesters, and someone, an unknown person, threw a brick that hit an officer who got injured. So the police brought on a lawsuit against DeRay as the protest organizer, stating that he was liable for these officers' injuries due to the fact that he organized the protest. He did not throw the brick. He did not know who incited violence. He was not encouraging anyone to incite violence. DeRay, by all means, was encouraging it to be a peaceful protest. But the officer did, in fact, sue DeRay, claiming that he had incited violence simply by organizing that protest, which led to the violence and injuries of the police officer. So, as we read for class today, this went up and up and up in the courts until finally in April 2024, the Supreme Court declined to hear this, which is, of course, a big win for our First Amendment rights and a protection for our right to protest. So this is, of course, a legal argument. We are going to be looking at it through a slightly different lens. We're going to be looking at it through a human rights lens. As we mentioned in the first class, human rights have historically been a legal doctrine, like they go through that legal academic profession, but I think it's important to utilize a human rights lens to social work practice. And as advocacy is so critical to social work practice, this is certainly applicable. So what I want to do now is look at this through a human rights lens. What does the human rights framework and those legal instruments say about this issue? So as we walked through in Module 2, let's start with the Universal Declaration of Human Rights. We'll go to the covenants, we'll take a peek at the treaty body website and see if we can find a general comment that speaks to this. So I'm going to start here, go to the OHCHR website. Oops. Just going to Google OHCHR. Okay, perfect. There we go. I'm going to go to the Universal Declaration of Human Rights. And I'll read the declaration. Now, I'm just going to skim these articles until I find one regarding a person's right to peaceful assembly or to protest. That is one of our basic human rights, so I believe we should be able to find that. You may see some that relate to a right to peaceful assembly or protest. Like everyone has a right to life, liberty, and the security of person. I'm sure you could kind of relate to that. Remembering that all of our rights are indivisible and inalienable. Um, so just thinking about how a couple of these articles could be applicable. No one shall be subjected to arbitrary arrest, detention, or exile. Another one of these New York Times, literally, you can search for DeRay, and it has all of the articles or pieces published on DeRay, and you can watch him filming his own arrest, which is really interesting, especially thinking about that witness video that we watched and the importance of using technology for advocacy. It can be a little triggering, especially if you've had any interactions with the police, so I didn't want to show that, but if that's something you're interested in, you can certainly go find that. Let's see. Here we go in Article 20. It says everyone has the right to freedom of peaceful assembly and association, and no one may be compelled to belong to an association. But really, this freedom of peaceful assembly is speaking to our right to protest. Now, where things get a little dicey and we need more information is this idea of peaceful assembly, because what the cops are arguing in the Doe versus McKesson is that this was not a peaceful assembly. When that brick was thrown, it defied peaceful assembly, and they are saying that DeRay was responsible because he organized the protest. And I don't know, like, given, you can tell I'm a little biased, just, I don't know. But given the nature and the tensions in the aftermath of the murder of Alton Sterling, that perhaps there was an expectation that it would get violent. I mean, there are definitely some racial undertones there. But let's take this Article 20 of the Universal Declaration of Human Rights. Remember, this is not a legally binding document. This is really the basis of all human rights. In the aftermath of World War II, people came together, developed these 30 articles that we believe all human beings are entitled to as basic rights, as rights holders, using that language. But we do want to find some legally binding language. So to do that, we're going to go to our legal instruments via our treaties or covenants. So to do that, again, we'll go up to instruments and mechanisms and go to those legal instruments. And of course, the topic of today's module is the International Covenant on Civil and Political Rights. In our synchronous module, we spent a little bit of time talking about that optional protocol, so I do want to spend a little bit of time diving further into the core treaty, and specifically looking at a right to peaceful assembly. So now we are in our ICCPR, adopted 1966. Let's look at the ratification status just very quickly. And just as a reminder, you do have to go down to this drop down to look at the ICCPR. When we do this, we can see, look, the United States has ratified the ICCPR in June of 1992. So the U.S. is technically held legally responsible for upholding the articles of the ICCPR. In fact, most state parties are. Now, I'm going to skip from what we learned right down to part 3, because as we know, parts 1 and 2 are sort of that overview piece, but part 3 is where we get to the substantive content. So we want to really find more information about the right to peaceful assembly. And you can see some of his language really mirrors what's in the Universal Declaration of Human Rights, but likely with a little bit more context. So I apologize for you having to watch this scroll on a video. Um, We're going to find it, I promise. Here we go. Article 21. The right to peaceful assembly shall be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health, or morals of the protection of rights and freedoms of others. So here again, need a little bit more context. We could see how law enforcement could argue public safety. Their job is to preserve public safety. I mean, you know, depending on how you view what police do, but they state that their job is to preserve public safety. So perhaps this was, you know, necessary given this, but to identify that DeRay was solely responsible, therefore bringing that that lawsuit, is really where we're parsing out those details. And as I'm sure you can imagine, the devil is in those details. So what we're going to do next is we're going to go to that treaty body website, the Human Rights Committee, which oversees the ICCPR. So we can hopefully find a general comment, which will give us a little bit more detail on what exactly the right to peaceful assembly means and how we can identify if from a human rights lens, what it says about DeRay's level of responsibility, for example. So again, I'm just going to bring this right up. If we go to instruments and mechanisms, we can go to the treaty body's website, and Human Rights Committee should be at the very top. Maybe not. Here we go, the third one. And you can tell that the Human Rights Committee oversees the civil and political rights, because it says it right here, monitors the implementation of the International Covenant on Civil and Political Rights and its optional protocol. So it also oversees those two optional protocols we talked about in our synchronous class. I'm going to click on more information, which brings me to the Human Rights Committee Treaty Body website, and we're going to look for general comments, specifically on Article 21, the right to peaceful assembly. So I can see general comments are over here on the left. Just going to click on that right away. And actually, we see in year 2020, general comment number 37, the right to peaceful assembly is there. Now, we can probably predict why in 2020 that there was a need for additional clarification on what the right to peaceful assembly means. You think about the resurgence of Black Lives Matter in 2020, the summer of 2020, and how important it was to understand what exactly the right to peaceful assembly was in a human rights context in the United States, at least. And how, I mean, that really was quite an international movement, if you think about it. So we have this general comment. Again, we see it in all languages. I'm going to pull up English. And what I'm looking for is to find some context to see if it states anything about, say, an organizer's responsibility to other people, like in a protest setting, an individual versus a group. So I've, of course, done some of this already. So you can see it brought me right down to exactly where we need to be. But let's pretend that it didn't know what I was talking about. We'll go back to the top. It has an introduction talking about and defining what the fundamental human right of peaceful assembly entails, how valuable it is, referencing Article 21 of the ICCPR, talking about how peaceful assembly is really synonymous with nonviolence. And when we get down to the scope of the right to peaceful assembly, we're going to get into a lot more detail. And you can see this is 18 pages. So when you want to know from a human rights lens more what is the right to peaceful assembly, we're going to really get into it. And so 17 says, there is not always a clear dividing line between assemblies that are peaceful and those that are not, but there is a presumption in favor of considering assemblies to be peaceful. Moreover, isolated acts of violence by some participants should not be attributed to others, to the organizers, or to the assembly as such. Thus, some participants in an assembly may be covered by Article 21, while others in the same assembly not. So this line 17 is really clearly articulating protection of DeRay, how he organized this peaceful assembly and should not, from a human rights lens, be held liable or responsible for the violence of others. And contextually, you can understand why that is the case. You know, if you are a organizer of an event, you cannot always control the acts of individuals attending your event. So I'm sure I could go on much more about that and, you know, these issues entirely, but I do just want to pause there. I hope this helps you sort of walk through those human rights documents, applying those human rights documents to a current event or issue, and especially how it pertains to social work, given the advocacy role that is so important to making effective change. So until next time, I hope you enjoy your learning activity, and I look forward to